boss is here.
We're live.
Oh, we are live. Good morning. The Senate Judiciary Committee, Friday, March 22nd. We're in the springtime months here in Vermont. The snow coming soon, of course. So, with that, our first order of business today is the confirmation of a Superior Judge, Kate Gallagher, Chief Civil Litigation Division, Vermont Attorney General's Office, but been, I believe, gone through the judicial nominating process, been selected by the governor as a new Superior Court judge. So,
good morning,
Kate,
Senators.
welcome back to Senate Judiciary. You're not a complete stranger here. You've been here before on a number of issues.
It has been a while, but I'm very happy to be here. It's an honor.
So why don't maybe tell a little bit about yourself, and you know Senator Wahowski, I believe you've met Senator Sheen, and then Senator Norris is on Zoom, and then Senator Baruth may or may not be in shortly. So if you would.
Sure.
And I'm Dick Seaton.
Yes. I more than know you, Senator. I've admired your work for many years. I'm from New Jersey originally, had gone to William & Mary undergraduate and the National Law Center at George Washington University. And despite the fact that I initially wanted to go into public service, that option really wasn't available to me given the amount of loans I had taken out for all of that educational efforts. So I spent the first 10 years of my career in New Jersey in private practice. While I wouldn't have chosen that, I actually think it was a really wonderful opportunity. I learned a lot of things that I wouldn't have otherwise practiced in, a number of areas that I might not have otherwise: products liability, toxic torts, commercial litigation, personal injury. But that said, once those student loans were paid off, I did the two things that I had been wanting to do for some time: move to Vermont and become a public servant. And it just so happened that as I had that opportunity, I saw a job opening in the Attorney General's office for their civil litigation unit. And it was, from my perspective, a dream job. And it still is. I love this job. I've been able to do an incredible amount of good work, I think, for the people of the state. I defend agencies and departments when they are taking actions, or individuals who have taken actions, and sometimes correctly, sometimes not. But I've also had the opportunity to defend the legislature, for example. I think one of the bigger cases that I handled for the legislature was the IMS case, where the legislature had created the prescription confidentiality law, which was a data protection law. And while including Judiciary, everyone knew it was a risk. We were able to try that case successfully at the trial court level, which was a surprise. Unfortunately, we then went up ultimately to the United States Supreme Court, and that case ended up changing, to my belief, in a negative way, First Amendment's rules on commercial speech. But it's not every day you get an opportunity to work on those types of cases. That said, I've also worked really the gamut. I've been involved in cases involving individuals, people who are incarcerated, people who have mental illness. I've seen a lot of, just a huge variety, and I really understand the importance of the work that government does and where government is effective, and hopefully you have worked to make it more effective in some instances. In particular, I'm quite proud, ironically, of my greatest successes as I see them are settlements, not necessarily court wins. For example, I was able to negotiate on behalf of the Department of Corrections with the ACLU to make sure that individuals could receive driver privilege cards and not be harassed at the border as a result of having gone through that application. So there were things of that nature that really you don't get an opportunity to do in private practice. And I think I'm looking to take that to the next level. Even at the Attorney General's office, I still have a client. So I still have a point of view that I'm presenting, but in the role of a jurist, you would be looking primarily for really a neutral application of the law, a fair application of the law, and an opportunity to treat litigants respectfully and hear them. It's an opportunity that I would welcome. It's one I haven't undertaken lightly. I thought long and hard about this before I did it, because I think it's a big job. It's a lot of responsibility, and I really had to say, am I qualified for this? Do I have the right temperament? And I came to the conclusion after spending some time thinking about it, consulting with others, that I believe that I could be an asset for the judiciary. I've got 30 years of experience that I think could be helpful. And I think the judiciary is in a bit of a difficult time period right now. The dockets are clogged. There's tremendous challenges facing us, not only as a state, but as a nation. And certainly as individuals in Vermont, it's not the easiest of times. So I'm looking to take my public service to the next level. And I would welcome any questions you might have.
I have a couple of questions, and maybe other committee members will as well. Why do you want to hold this position? You said to me an interesting comment. I believe I could be a positive force in the judiciary and the community at a time when respect, kindness, and compassion seem in short supply. Could you expand a little bit on that?
Sure.
And why you feel that?
I think
first of all, that I would tend to agree in many ways. Respect, kindness, and compassion seem to be in short supply. So I'm not arguing that it isn't, but I'm just curious as to your using that term. And
sure. I think, and I don't know if this is COVID or if this has been a trend that's been going on longer, but I think people are a little more angry, a little more willing to ascribe negative motive when maybe something is just inadvertent. I think we all have been through a very difficult time. I think with COVID and historically in terms of politically what's been going on. That of course is not isolated to any particular party or even the last few years. It's a trend that's been growing, but it's one that I think we really have to stop. It's one that I think the judiciary is very well suited to addressing. I mean, the judiciary is the last stop for truth. It's the last stop for the arbiter of what is right, what is just, and what certainly where mercy fits into all of that. So to me, and I've dealt with pro se people in litigation. Most of the time, people just want to be heard. They want to be respected. They want you to explain to them in clear terms why you're taking a particular position you're taking. And because the judiciary is really the public face of government to many people, and the only face of government for many people, it's absolutely critical that those people feel heard and respected, because the judiciary has its authority simply because of its moral authority. There's no army that's coming in and enforcing your laws unless the executive says to do so. And so respect of that authority is critical, and that respect comes in part from giving respect.
But I would say, particularly in the United States Supreme Court level, that public confidence is at an all-time low with the federal judiciary. And I suspect, from what I hear from constituents, particularly on the criminal side, the confidence in the judiciary is lower now than I can remember in Vermont. Just as an example, somebody's released or bail is set at a certain amount. Why would you set it that low? And then you find out, well, that was the state's attorney's recommendation. Nobody holds the state's attorney accountable for that bail recommendation. It's the judge who made that decision. So I would disagree, and I think we could all use a loop.
Yeah, and I would agree that Vermont, this United States Supreme Court and its lack of transparency, and its what seems to be naked political infighting sometimes is not helpful for creating confidence in the judiciary.
Most of your, at least the past 10 years, has been spent in civil litigation, not on the criminal side. Do you have particular views? How are you, I mean, most of the candidates that we see have either been former attorney generals who did, or state's attorneys who did criminal work, or public defenders, etc. You're the one who's done all the civil litigation. So how are you going to deal with the criminal and the juvenile dockets?
So you're absolutely correct. Not only the last 10 years, but my entire career has been in the civil arena. That said, I have sort of had to understand criminal law principles and family law principles because much of the case work I've done has involved, for example, like excessive force. So I'm looking at principles of use of force, or what's appropriate in the context of criminal proceedings in, for example, a malicious prosecution case I've defended, or other types of matters. So I've had some familiarity with the criminal docket, some familiarity with the family docket, given the work I've done for the Department of Children and Families. And particularly the juvenile docket there. I spent a lot of time working, frankly, to assist with transitioning the Woodside facility, which while I appreciated the hard work that folks were doing there, that was a very difficult transition for the department. So I've learned a lot. That said, I'm going to have a pretty steep learning curve on those things. I will tell you, though, that Judge Torr sent me a note where she said she was glad to see that there was going to be someone whose strength is civil, because if we like to have a little bit of balance, there's, of course, much of the docket for a judge ultimately is civil. But I will, there's no question, Senator, I'm going to have a learning curve. I'm kind of excited about that. It's a good opportunity for me to learn something new. It's challenging. And that's part of why I went through this process, is I am ready for a little bit of a different challenge.
And as you know from your civil background, you're ready because you will not satisfy all of the people all the time.
It never happens. Well, I know that mostly from my years as the commissioner of the Department of Human Resources, where everyone is angry with you.
Now, no matter what you do, somebody will be angry. Senator Bahowski.
I also have a couple of questions. So one of the things that you said is that you really look forward to the neutral application of the law. First, I think it's important, at least in my view, to recognize that the law isn't neutral. The law is a measure of who is in power and who, and so I wonder how you, and I think the other piece of that is neutrality often only lifts up that power and is not actually a fight for justice. So how do you anticipate having a fair application of law and challenging injustice?
Right. And I think that's what I was trying to get at there, is the difference between what is a fair reading of the law versus when you exercise discretion. There are times when a judge is not permitted to exercise discretion, that, for example, you have all made a determination about what it is a judge can or cannot do, and you have to follow that. Mm-hmm. That said, you're absolutely right. There's a power structure that has created some of this law. Hopefully, as we have created diversity in this body, that diversity becomes reflected in the law. But I also think that more importantly, from my perspective, is I have to recognize my own biases. And that's been an evolving thing for me. I think I always assumed I had biases, but I've been, like you do a couple of those tests from Harvard and all of those things, and you really do realize some of the things you thought you may have been biased on, you're not, and then other things And I've had great opportunities to have some trainings. I most recently, the National Association of Attorney Generals did one at the Attorney General's office that was so enlightening. And so I think the part of it is not just, try understanding what I meant by a neutral application of the law is there are bounds within which a jurist can act. That said, you need to exercise your discretion in understanding. And I think, compassion is an important component of what a judge does. I don't believe there's justice without mercy. So I think you really have to be careful, thoughtful, and respectful, and do your very best to eliminate your own biases. Not necessarily easy. I think, you just don't know sometimes. You don't know what you don't know. And if it's a bias and also I think, sort of looking for guidance from others, asking them for feedback about difficult things like, what do you think? Am I doing this correctly? Am I too harsh? Do I have a perspective that's maybe not as balanced?
That's helpful. And what do you see as the judiciary's role in the use of restorative justice?
Well, restorative justice is, I think, first of all, it's a broad concept as opposed to just a program. And I think that it's a mindset of what is the importance? What are we looking for in terms of when we enforce our laws? Are we looking for retribution that gets us nowhere? I mean, in the end, what I think we're looking for through restorative justice is not only holding people accountable, but doing so in which we bring them back into the community. And if we do that successfully, we will have less problems going forward. And it takes a ton of resources to do that well. But I'd love to see all the data on that. I bet and as the Vermont judiciary gets more data driven, as we've got more access to data, I'm hoping we'll find out more. But I've had friends and family members who've gone through that process. I have a friend who actually is someone who's in a community volunteer, and the people who I've talked to who've gone through the process have found it extremely effective. I think it might be hard sometimes for a victim. Now, the judiciary's role is to encourage that and encourage not just the specific programs, but I think to in sentencing in particular, to be thinking about justice from a restorative perspective as opposed to a punitive perspective.
And how do so you already touched on this and in your application touches on it some too, how do you sort of envision going forward and continuing your reflective process of examining your own bias? What does that look like for you?
Well, I think reading more, thinking more, talking to people more. I think I would like to participate I would like to know what the judiciary itself is doing right now for that, and encourage, if not, I'm not, obviously I don't know, but I think it's a constant process, a constant examination. It's even something as basic as the use of language, where there are certain words that I did not understand to be offensive that I now know are offensive. And that's a process. And, it's keeping up with that. It's, hopefully learning, because I know I'm far from perfect. I know I'm biased, but I know that I need to take steps to protect and correct for that.
I appreciate that. I mean, we all are, right?
Right.
None of us are perfect. We all have bias. So I appreciate your openness to continuing to examine your own. That's all I've got.
Senator Sheen,
I'm good, yeah.
you met her through the.
Yep, yeah, we've met and
Which I have to say, I thank you for your service on that committee. Boy, is that a lot of work you must have go through, and I enjoyed that process quite a bit.
Oh, I'm glad to hear. I know Senator Norris enjoys it.
Yes, it's. Are you?
He's on it.
Good morning. I don't have any questions, obviously, because I met Judge Gallagher along with being on a J&B also. But welcome.
Good morning, Senator. It's nice to see you, and
Thank you.
thank you for your service. I have to say, it was wild because it's this process where you've got, 10 people, firing questions at you in a half hour but it was really fun to engage and to learn what other people were interested
It was
in.
one of the most demanding committees I've ever been on. I was on it for 4 years back in the 90s. And I found it also one of the most rewarding because you really got to, we actually did check references, unlike a lot of people. I think a lot of people don't bother to check references. But I know that, sometimes you're on the phone with somebody for half an hour as a reference, and they just won't talk to you, but
And I understand the process is a little different now, that there's like paperwork that references now fill out.
yeah,
this way,
right.
Which that was not back in the
They
day.
didn't do that when I was on there.
I was one of those
I was
people on the
actually
phone.
on the Judicial Nominating Board with Chief Justice Ryder,
Mhm,
so that goes way back.
yes,
Oh, when he went through the process?
No, he
Oh,
was
he was
a
on-
member of the
oh.
Judicial
Right.
Nominating. He was the local
Right.
Bar Association member of the Judicial Nominating Board. So he and I got to know each other through that process long before he became a justice.
it's still an impressive group. You'll be glad to hear.
Ben, if we can schedule for next Friday, a few minutes to have a vote on Judge Gallagher, and gives a week for anybody with any comments that wants to make public comments they should get in touch with Ben Dorbach here at the Legislative Council, and he can make arrangements.
My contact information is on the website.
Yeah.
Just email me.
So if anybody out there wants to make comments, public comments, we have time for that. And then we'll have a vote next Friday.
Thank you.
Thank you very
Really,
much.
true honor.
Pleasure to see you.
You too.
I just emailed Ben Novogoski time to make his way down, so he should be here soon.
Okay. We have the amendment from Senator Brock to S-285.
I'm leaving it on the screen.
Yeah, I had kind of a discussion with Senator Brock about the reading feelings about it, that it's been discredited, and he said, no, I used it, it's not discredited. Police forces use it now.
So I'm passing out your 285 folders just in case you want that information. And then per request, we got a highlighted version which has the changes made from the version that was passed or recommended by you.
All right, thank you. Something was up to give. Here's the rest.
It's okay with
Can
the,
you just open the door to see if there's somebody out there?
there is not. I am gonna run and grab Senator Booth and see if Senator Brock can come in now, if that's okay with you. You want me to keep us on live?
Sure.
Okay,
Just remember we're all live. Somebody.
I'll be right back.
Happy Friday, everybody.
Good morning.
Maybe a little too soon to say happy Friday.
Well, if I lived up here, I might get a word Saturday.
Yeah. an interesting one.
Yeah. Once again, we're not supposed to get much in Bennington.
It's getting worse. The predictions are getting bigger and bigger in Chittenden County.
Yeah, what is it, like 8 to 17
What are they
inches?
now?
18 inches.
18.
Yeah. But we do have, Catamount's playing the
CAX, the
Dukies
largest
tonight,
snowfall you've had this year, like 7 inches.
Something like that, yeah. And I think it might have been like 2 weeks ago.
Wearing the greenest tie I have in honor of the Catamounts today.
Well, I got my Catamount hat on.
Yeah.
I thought I'd wear it today, but I didn't.
It's gonna be a tough one.
Speakers, Secretary Bloomer says I can't advertise with
Ooh.
the hat.
Oh,
I can wear a hat, but I can't advertise.
okay. Good to know.
But anyway. So do you want, we can start by walking through the amendment and
Sure.
then, Senator Brock can explain why he wants to do it.
Senator Brock will be here shortly.
Okay, well, I'm gonna have Ben walk through the amendment then, and then we'll understand it. And Senator Brock. So what's highlighted is what's been taken out or put in.
Exactly. And so for the record, Ben Novodrowski from the Office of Legislative Counsel, before the committee today is Senator Brock's amendment to the committee's report on S-285. Essentially, on a high-level overview, the changes limit the model policy to just juveniles and take out anything that would concern other individuals. Juveniles are also, there's no age associated with juveniles in this bill, so under common parlance, it would probably be considered those, 18 and under. So that's sort of the general overview, but to get into the details of it, you'll see in section 1 in the first paragraph, what was previously inserted as a reference to progress towards a total prohibition of the use of deception in all forms of interrogation. That language has been removed. So now it would just read that it's the intent of the General Assembly to prevent false confessions and wrongful convictions of individuals subject to law enforcement interrogation and to ultimately improve trust between Vermont's communities and law enforcement. You'll also see that old subdivision 1 has been replaced by removing the prohibition or prohibiting law enforcement's use of threats, physical harm, and deception during interrogations of all persons as part of what the further intent of the General Assembly is. And now it just reads that it would addressing the use of deception during custodial interviews of juveniles. There was actually a grammatical mistake here where I had left and the editors also didn't catch the word consistent, but depending on what happens, if the amendment is incorporated, that's addressed here. If it's not, I've spoken to Secretary Bloomer and that shouldn't be an issue as far as it making it into the final form. Moving on to section 2, just another sort of grammatical change. It removes in consultation with the Office of Attorney General and just says that the Law Enforcement Advisory Board and the Attorney General's office shall collaborate. Again, you'll see on line 21 of the document that all persons is removed and replaced with juveniles. Turning onto page 2 of the highlighted document, you'll see again that various forms of interrogation is replaced with custodial interrogation. And then the model policy shall include the definition of deception that was in the initial report of the committee. But it removes the 4 items that were previously there, referring that the model policy shall include custodial interrogations occurring in a place of detention, custodial interrogations occurring outside a place of detention, interrogations that are not considered custodial regardless of location, and the interrogation of individuals with developmental, intellectual, and psychiatric disabilities, substance use disorder, and low literacy levels. Those have been removed and have been replaced with that the model policy shall define deception. That definition is the same, and that the model policy shall address the use of deception during the custodial interviews of juveniles. And then again, you'll see on page 3, the removal of the model policy shall also address other forms of interrogation involving persons under 20 years of age wherein the use of deception is prohibited, and that the model policy shall prohibit any training of law enforcement officer that employs the use of deception, including the Reed technique. That has also been struck. And then those changes are also mirrored in section 4, which is the statute itself, not just the session law developing the policy. But those changes that I just went over are also incorporated into the statute. And then that's it.
Thank you, and we're gonna ask Senator Brock to, thank you for walking through it, it's very helpful. Senator Brock, thank you for being with us this morning, and
Thank you, Chair.
maybe you can help us understand your strike all amendment to S 285.
Thank you, Mr. Chair.
I
For the
mean,
record,
I think we understand what you're doing. The question is,
yeah, I can
why
be
are we
very
doing
brief.
it?
I know how busy everybody is. This is Senator Randy Brock for the record. And I hope Legislative Council gave an entirely truthful and deceit-free description of what the changes are in the bill.
We didn't interrogate him, so I don't know.
Well, that's one of the questions.
It is custodial.
Yeah.
Yes.
One of the questions I had underlying the original bill is, what is an interrogation? Interrogation I view as asking questions, and where it was extended to any location. The first thing after I read the bill originally, I said, well, what if you're a police officer and you don't identify yourself as such, and you visit with someone on the street, another location other than custodial or other than the police station, and you begin asking questions, such as, do you have any heroin to sell, Phil? No. That's an interrogation, isn't it? And if you say you can't deceive, and when Phil comes back and says, you're not a cop, are you? And you say no, then you committed deception in violation of the way this particular bill reads in its origin. And I don't think that's what was intended, but that's one of the unintended consequences. Deception as part of interrogation is surprisingly widely common. It's common both in interrogations done for law enforcement purposes, but interestingly enough, it's also common in interrogations that attorneys use on their own clients. Certainly in polygraph examinations, the pre-test interview prior to giving the examination is a form of interrogation done by law enforcement and done by private polygraphs. And the reason for that is because it tends to elicit information in a way that you don't elicit by straight questioning. I remember years ago, and in terms of the Reed technique, I was trained, I hate to say how old I am, Senator Sears, but
Feel free.
I remember that my first training in the Reed technique was done by Richard Arthur, who was a disciple partner of John Reed back in the 50s, and I got that training from Dick Arthur, offshoot of the Reed technique in 1972, my first training, and used it quite frequently. And I used it a lot in Vermont, doing polygraph examinations, both for law enforcement agencies as well as for the Defender General's office. A technique that I used, for example, if you all have heard of the case involving Paul Lawrence. It was perhaps the most significant case of law enforcement misconduct in Vermont history. And Paul Lawrence went to jail, and 100 people were pardoned because of his false testimony in drug cases. And I remember doing polygraph examinations of at least 30 of his victims for the Defender General's office. And I certainly used deception there in every one of those examinations and pre-test interviews. And it was very valuable in setting up control questions about what they did or did not do, who they knew or didn't know, which was all relevant to being able to conduct a proper polygraph examination. Right now, I've heard some myths about this bill. that we don't use that. There's very limited use of deception in interrogations in Vermont, and I don't believe that's true. And certainly from the people that I've talked to in law enforcement, as well as law enforcement leaders, they believe that deception, a form of deception, at least as far as adults are concerned, is a valuable technique, is a useful technique, and it's a legal technique. There's a long history of challenges to the use of deception in interrogations nationally. And we have a Supreme Court decision and at least 3 decisions of federal courts of appeal upholding the ability to use deception in interrogation. And of course, we have here in Vermont a case as recent as 2018, and I'm sure you were perhaps told about the case at Middlebury involving a sex offender, a juvenile, who was interrogated using these techniques by a Middlebury police officer, Middlebury police detective, and that was challenged to the Vermont Supreme Court. The Supreme Court upheld the use of deception in that interrogation, and it resulted ultimately in the conviction of someone for child molestation. We know that there have been mistakes, but to the best of my knowledge, I have not heard of, and I've inquired diligently, whether or not we've had any false confessions resulting from an interrogation deception in Vermont. And to the best of my knowledge, I'm not aware of a single case, and deception has been used in interrogation in Vermont for many, many years, and is being used today. There are police officers in Vermont, indeed, in the state police, who do use deception in interrogation. Yes, there are other techniques. The peace technique that I'm sure you've heard about is a change in structured interrogations that has become more widely accepted in recent years. But the Reed technique, or a variant of it, and there are many variants of the Reed technique, is still widely used today. That said, I drafted this amendment. I drafted the amendment, though, after talking with the Commissioner of Public Safety, who opposes the bill as it's written now and is supportive of the changes that are made in this amendment. And I also spoke with Charity Clark directly about this, and she is also in favor of the changes in this bill and not in favor of passing the bill as written. And I've talked extensively with the General Counsel for the Department of Public Safety and also an attorney in the Attorney General's office who Charity Clark asked to perhaps consult with me about this amendment. And I've gathered that both are supportive of it, although clearly you can ask them yourselves. What the amendment does in a nutshell, without going into infinitesimal detail, you've gone over the amendment, is it simply says that interrogation of juveniles using deception wherever is not in custodial environment is not appropriate and is prohibited. It leaves out any other form of the use of deception, but it does provide that a group will look at the whole issue of law enforcement interrogations and come up with a model policy to do that, and leaves them free to come up with whatever model policy they deem appropriate. That in a nutshell is what the bill is. And I'm pretty happy to answer any questions if I can.
And I'm in a unique position. I introduced the bill, and I voted against the bill in committee. But I was convinced and remain convinced that the Reed technique is not appropriate. I remain convinced that juveniles do provide false confessions, whether they're in Vermont or New York or wherever. Frequently, deception results in false confessions. And I've been around here long enough to have remembered Paul Lawrence, remembered a lot of different cases where there have been confessions. I can't point to a specific one this morning, but this committee over the years has worked closely with the Innocence Project and passed many bills related to the Innocence Project. And some of them had to do with the ID, using photo lineups where people identified someone, and there was a 60 Minutes just did a recent, I think it was this week, of people who I had identified their perpetrator, and they got the wrong person, and this group has put them all of them together. We did hear from the picking cotton, and his name was Cotton, his last name was Cotton, and the ID was him. He served 10 some plus years in jail, and then by accident, the actual perpetrator ended up in the same jail, in the same area as Mr. Cotton, and admitted that he was the one that raped the woman. And he was exonerated. I remember doing DNA, and having a man from Massachusetts, actually my home county, Middlesex County, Massachusetts. He was a sergeant at Fort Devens and charged with rape. Got convicted, spent 18 years in the Massachusetts prisons. And partly the length of his sentence is he wouldn't admit that he had done the crime. And if you don't admit you're a sex offender, you can't get out in Massachusetts. And he was proved innocent by DNA. So over the years, we worked closely, and this is another priority of the Innocence Project. But it was focused particularly on juveniles, and that was because they are more likely to elicit false confessions than adults.
Yeah, and that's why in particular, I did this amendment and did in fact limit it to juveniles, because clearly there is that possibility.
Our testimony on the Reed technique was very compelling, quite frankly.
I'll let about the Reed technique, though, that the Reed technique has numerous variants that don't use the Reed technique as a Bible and follow it on a step-by-step basis. I never use the Reed technique as it's written today, as they describe each one of the stages. But I certainly did use a variant of the Reed technique, and there are 4 or 5 variants that are very widely used by law enforcement agencies in the United States. But where there are false confessions, particularly of adults, absent someone who has a serious psychiatric problem, which there is that possibility. But generally speaking, and again, part of the technique of a good interrogator is to have a good medical history of the person that they're interrogating. Certainly, if not at the beginning, certainly at the end, because it deals with the validity of the information that you've obtained. And it's important to know that. But at the same time, I know that when there have been false confessions, in a huge number of those cases, there have been other forms of misconduct, such as abusive interrogation techniques, techniques that use threats, that use violence, or that use promises of leniency, all of which are improper. But they're improper in the Reed technique as well. But it's people who use the technique and who go beyond that and add those other elements that lead to false confessions.
Senator Ruth and Senator.
I am interested in the Paul Lawrence connection because I wrote a book where about Pat Leahy.
You wrote it or read it?
I wrote it.
Yeah, Pat Leahy.
Right. And so
I've read your book.
Yeah.
I'm sorry.
So he directed the sting that caught Paul Lawrence.
Yes.
And that was done through a fake personality called the rabbi. And so they wouldn't have got Paul Lawrence without setting up a false identity and then trapping him in how he handled it. So that I fully understand and I'm fully behind as a law enforcement technique. But when the person is taken into custody, at that point, if the state continues to deploy deception in order to produce the results that it wants, and I know what you're saying is that it's effective, But it seems to me it reduces the difference between Paul Lawrence making up cases and interrogators who are making up information. Then you have a system that's just being polluted, corrupted, tainted at several levels by deception. And so the piece that I can clearly support is the way they constructed the sting to get Paul Lawrence. But I voted for the bill to come out of committee with deception prohibited for everybody, or moving toward that, because it just seems to me it's a corrupting influence in law enforcement to have it be an accepted technique to lie to anybody of any age. And I think Senator Bohofsky has mentioned a number of times that Europe doesn't adhere to this standard. They have a higher standard for honesty by law enforcement. Does that mean that you don't get every perpetrator? Maybe. But it seems to me it's more in keeping with how you want law enforcement to be handling the responsibility and the powers they have. So that's my.
I understand where you're coming from in this on the one hand. On the other hand, in terms of the study of the appropriateness and the legality of using some forms of deception under controlled circumstances in interrogations has been tested by the courts over and over again here in the U.S. Right. The first decision was, I think, the Supreme Court decision in 1969, and you have numerous decisions since then, both by courts of appeal at the federal level, and you have, again, a most recent decision, even by the Vermont Supreme Court.
Well, and I'm not disputing that it is currently legal. We're passing statute to make it illegal. So,
and as far as I know, the extent to which this is the only one in the nation, my understanding, that does that to this extent.
Well, there'd be only
There are
one.
7 other states
I
that,
think they're all juvenile.
I think Minnesota's in process for a complete ban.
But I don't think there are any other complete bans, unless the information I've got is correct.
This also isn't a ban, this is model policy.
Yeah.
All right.
I did want to echo that it's not just Europe, it's the UK, it's New Zealand, it's Australia, and the UN has actually, the General Assembly of the UN in 2016 came out and said the Reed method should not be used, and worldwide adoption of the peace method is what they recommend. So I do think that that is important. You know, we can look within the confines of what we're doing here and what we've always done, but we know throughout history that as we gather more information and we gather more evidence, sometimes what we've done in the past isn't the best thing to keep doing. The other thing I think is important, and part of the reason, especially because there isn't a ban in this bill, it is directing model policy to provide other tools, more evidence-based tools. I do think it's important to look at the numbers, and the Innocence Project has done a study of 397 exonerees who were exonerated based on DNA. 36% of them were on false confession. The number of that 397 for below 18 was 96 people. The number of people between from 18 to 25 was 155, and the people 25 and above was 146. So this does happen to adults.
One of the things, though, that I think is very important, there's a book called How to Lie with Statistics. It was written in 1977, and it's one that I've used a lot over the years. I would say that take those 300 cases and delve down into them further and say what else besides deception led to that confession, and to what extent were everything from loud voices to threatening to coercive behavior, false promises were also part of what led to those confessions, because that is the thing that you see most frequently when you go and you delve into those cases of what went wrong.
And
so
thankfully, this model policy would prohibit all of that too.
And well, yeah, the policy right now does prohibit that. And you know, if you find a law enforcement officer in Vermont who does that, it's already improper. And so you're not gathering that piece. It's when the two are combined that you have much more of a potential for a problem. And as I say, I was not able to find a single case in which a false confession occurred as a result of deception by a law enforcement officer in an interrogation in Vermont.
Well, I would just connect that up to what Senator Volhovsky was showing. Those were places where DNA had exonerated the person. So we could have numerous people in prison right now under false confession. We just wouldn't have a way of proving it necessarily.
Well, at the same time, though, you have to add in, I believe, the other forms of misconduct that also were occurring simultaneously, and attributing it solely to a quote false confession is not necessarily the case. And what are we talking about? About false confessions, about false information that's given? Well, very often it is simply something such as a rape person, a person who's suspected of rape, accused of rape, and in the interrogation, the police officer says, you know, there was a rape kit done on the victim. And when they do the test of that kit, what if it comes back and it shows that it was you? And no such rape kit test was done.
But I remind you that this is setting a model policy by, it's not banning anything at this point. It's not like the original bill.
You know, what's not like the original bill?
Well, the original bill
The original
wasn't.
bill
Yeah.
banned deception.
Ban deception.
This one is asking that law enforcement.
But the amendment that I'm proposing is
No,
asking
the
that.
bill itself, I believe, the bill itself is only asking for a model policy.
Well, as I understood the bill itself, that you ban the use of deception.
Ban any-
It's not banning.
No, that part's been removed from the bill.
Ben,
Well, no, so in the model policy, one of the things that we need to adopt is that the model, under the report of the committee, the model interrogation policy shall prohibit the use of physical harm, threats, and deception during custodial interrogations of all persons.
Right.
And then it goes into what deception is, adopts the Illinois definition, which deviates from what the committee had previously debated before, and then that the policy shall address other forms of interrogation for those under 20.
And so that's a ban.
Well, nothing's banned yet until we have a model policy.
But if the model policy, if you're directing by law that they come up with a model policy that bans it, that's effectively a ban.
Senator Norris, do you have any comments, questions?
I do, Senator Sears, thank you. First and foremost, I appreciate everyone's opinions. Data is nice. Data is not the do-all, be-all. In the real world, which I have experienced, a form of deception is a very valuable tool in the law enforcement arena. And my personal opinion is that this bill, after the change was made, it does ban deception in law enforcement. You can look at it any way you want. Everyone has their own opinion. When we were originally looking at 19 and under, then we created it from 18 to 21 and went above that for all individuals of any age. This bill does ban deception. And I do support the amendments.
Any other questions or comments for Senator Brock? Thank you for
Thank you very much.
taking time with us. What is the pleasure of the committee on this amendment?
I mean, I am gonna surprise no one when I say my preference would be that we find the amendment not favorable and we stick with the original bill, or the bill that we passed out of committee.
Senator Bahowski has moved that we not accept the amendment. And so, is there any further discussion?
I feel similarly. This returns us to the discussion we had on the original bill in terms of whether to be under, this is under 18, I think.
Yeah, the age isn't
Well,
defined,
yeah.
but
He doesn't define it, which is actually helpful.
Yeah. In any event, it takes us back to a decision point where we already expressed the will of the committee. So I would just stick with that and say, I appreciate what Senator Brock is trying to say and trying to do. I have to say it is disturbing to me overall and in general to hear so many people use the phrase deception is a key tool in our toolbox. Just the casual way that keeps getting rolled out is disturbing to me, because post George Floyd, I feel like the trust deficit in America is profound. And in our conversations, to have so many people talking about deception as an important tool, one that advances the public good, et cetera, where does that stop? I mean, it seems to me it's a very slippery slope. So as much as a full ban might be a big change for Vermont and other states, I feel like it's a direction we need to be moving in, and this is actually a slow move to it rather than a fast move. So, I mean, our original bill is a slow move to it, so I would stay with that.
I'm gonna vote against the amendment, but remain opposed to the bill. And my reason for voting against the amendment is the Reid policy. I heard too much information in this committee over the last 2 years about the Reid technique and how it should not be used and how the Vermont State Police don't use it. Most police agencies in Vermont have rejected it, and there's only a couple that use it. And so for that reason, I'm not supporting the amendment, but I will, I still think that his way of limiting it to juveniles is helpful. Anyway, did you wanna?
I did, and it is about, you know, the Reid method and the practice largely. I think a lot of times, we do the best we can with the information that we have, and in the 50s when the Reid method was developed, that may have seemed like it worked and it was good, and what we now know is we have additional information, and we have additional information about the negative implications, and we have new methods, and I know that change is really hard, but I mean, once upon a time in this country, we felt like forced lobotomies were a good treatment for mental health issues, and we've now come to realize that that is abusive. And so I think that this is a space where, yes, it is hard, and it is hard to look back at what we may have done and recognize that it was harmful, but we have many years now of evidence that there's a better way. And so I really appreciate the lean in to doing things better.
So, the motion is to not accept the amendment. Would you call the roll, please?
So a yes is to
Reject.
reject the amendment.
Yes.
Okay, for my,
Maybe we could restructure the
Yeah.
amendment, whether we support the amendment or not.
Yeah, I think it's easier.
that's what
I
my
don't know
sheet-
how to make that motion.
Well, the motion is to accept.
The motion is to withdraw the amendment?
No, I'll make the motion.
Okay.
Okay, there we go.
Accept the amendment.
Okay. Senator Brewer,
No.
Senator, Norris,
Yes.
Senator Mahalski,
No.
Senator Hashim,
No.
and Senator Hughes.
No. So I've accomplished voting against my own bill, voting against my own motion to. So this is really screwed up.
You're reaching Bobby Starr territory.
Yeah, well, Bobby will get confused. And I'm not saying a word on the floor. And I appreciate you're not saying a word yesterday.
Absolutely.
on that.
Although at one point I thought you were asking me to say something.
No.
When you suggested that other members weigh in on testimony, I was like, is he suggesting I say that? Because I'm not gonna.
All right, well, now this has been an odd morning. We go from deception, we go from a judge to deception to the Human Rights Commission.
The glory of the judiciary.
The glory of the judiciary.
Okay, so we'll make a quick point. I mean, the vote has already taken place.
Oh, I'm sorry, Marshall, I thought you were here for the Human Rights Commission.
No, I just wanted to make one quick point regarding Senator Brock's testimony, which there was a large part of, which I thought was completely factual. But when he stated that lawyers use deception, I just wanted to make clear, that's not true. We are far from lying to our clients. by Rule 1.4 and required from making counterfactual statements to third parties by Rule 4.1. So the idea that this is, and that's actually not true of our counterparts, prosecutors. So our law, our rules against deceiving our clients or deceiving third parties, we also have to ensure that our investigators follow the same rules under the rule on non-lawyer legal assistance. Whereas prosecutors don't have that same limitation. Police can engage in deceptive practices where our investigators can't, but neither prosecutors nor defense attorneys nor attorneys in any other field can lie to their clients or third parties.
What were the rule numbers again, just in case?
1.4 and 4.1.
1.4 and 4.1. 1.4 is the section on relationships with your own client. Section 4 is the section on relationships.
Yeah, I'd heard
with third parties.
that lawyers can't lie to their
Not even the third parties, we don't get to lie in.
That's just in the rules of professional conduct, right?
Yes.
Thanks.
Thank you, Marshall. I'm sorry I didn't ask you for your comment.
It didn't seem necessary during the process.
And now Dick Hartman could join us. We usually don't look, although we're the committee that has the responsibility for confirming members of the Human Rights Commission. We don't usually look at the budgets or the issues of the Human Rights Commission, but during the testimony in appropriations, what we heard was that you're being asked to intercede in all kinds of matters, some of which are not in your purview, and you're becoming a referral source because of the lack of services the lack of legal services that particularly low-income people. Am I stating that correctly?
I think,
I'll let you state what the problem is.
okay, sure. For the record, this is Big Hartman. I'm the executive director of the Vermont Human Rights Commission. I use they, them pronouns. Thank you so much for inviting me to speak today. I know it's a really busy time here. Yeah, I wasn't totally sure what aspect of my budget you wanted to hear about, but I can share generally what I'm concerned with. I spend a lot of time obsessing about our agency's budget. It's extremely tight. I feel like this office has been operating on a shoestring for the whole time I've been here and long before that. And that results in a lot of strains. First of all, we're not able to take as many cases as we otherwise would. We have 3 areas of jurisdiction. We are the only agency in the state investigating fair housing complaints, violations of we have a federal grant to basically handle things that HUD would otherwise handle under both federal and state law, to enforce fair housing protections for people seeking to purchase homes, people seeking to rent, tenants, anyone who's discriminated against in their housing. Our second area of jurisdiction is discrimination in places of public accommodation, which is extremely broad in Vermont. It's basically any place that serves the public or is open to the public, including any government entities or government action. And our third area of jurisdiction is state employees who are facing discrimination, and those represent the smallest proportion of our cases. We have 3 investigators working statewide, and frankly, it's not enough. I was an investigator for about 2 years before I became director, and I was handed cases that were 2 and 3 years old. People had been waiting for their interviews to even be conducted in their cases, let alone the legal issues analyzed or anyone having conversations about settlement. And one of our really important functions is to help parties do conciliation. You know, a lot of folks are coming to us unrepresented, and they really need a middleman to, so to speak, to facilitate conversations about how to resolve the issue and move on with their lives, which is what most people come to us hoping to have happen, to have their story be heard, truth be found, and justice served.
I feel it's nearly impossible for us to serve the demands with the current staffing levels that we're at right now. I submitted a little kind of one pager for you to summarize the positions that we are recommending be created. I also brought some copies of our annual report, which covers fiscal year 23, but I was director when I was writing this and really wanted to help anyone who was reading it see where we accomplish a lot of work, but we aren't able to, do our work very efficiently with the staffing levels that we have. So would you like me to go through what the positions that I'm proposing are, or do you want to talk about, we also are looking at our fiscal year 25 budget, which is underfunded. The governor recommended almost $25,000 vacancy turnover savings, which I genuinely don't know where they think that money is coming from. I am not anticipating turnover. I only have 7 positions total in our office. If we have turnover, it results in work stopping, everything being on hold for whatever that person was handling, and then there's always going to be some gap before that position is filled.
You can cover anything you'd like, but what I'm looking for specifically from both the Human Rights Commission, Vermont Legal Aid, and the Vermont Bar Association is access to justice, particularly for people who don't know where to turn. I get calls frequently from people who are desperate for some type of legal assistance, and not criminal, but civil issues, parental rights, grandparents' rights. They think they've been discriminated against, or they think that somebody's, accusing them of discrimination.
Yeah.
They don't know where to turn. And they end up being very frustrated, and I end up being frustrated because there's nothing available.
Right.
So I would I realize that it's not, you're a limited function within the Human Rights Commission is what you can deal with, but you're also limited in even what you're supposed to be able to deal with by your lack of staffing. Is that
correct?
Accurate.
Yes.
So you can cover anything you want, but what this committee's looking at, quite frankly, from those 3 groups I just mentioned, is access to civil justice for Vermonters.
Yeah, and I really see our office as being a gateway for people who don't have attorneys to be able to find some access to the system of justice, because we are set up to handle cases where no one is represented or only one side is represented, and we field calls every single day and emails because we're called the Human Rights Commission. People think anytime their rights are violated, they should call us, and we are most often having to refer them out to either the Vermont Bar Association Lawyer Referral Program, which has a lot of challenges itself, and I hope you get to hear about that, and Vermont Legal Aid. Vermont Legal Aid is one of the primary places we're referring people to, as well as Disability Rights Vermont. All these agencies are really struggling to meet their own needs as well. So, but when someone is articulating at least something that could amount to a complaint with us, it's a very time-consuming process for them to go through what has brought them to calling us. It's not a 5-minute phone call. It's an hour or 2. It's a lot of back and forth questions and answers. We have one person who handles all of that work in our office, and she also performs all of the administrative support for our office. So that's the executive staff assistant. That position tends to be a bit of a revolving door. People can only really last about 3 years, and then they burn out. And it's a really, it's an important place where that person has to be really knowledgeable about what's going on in the state. What are the other avenues of support that this person may need? They may need interpreters, they may need translators, they may need, to speak to a court system, they need an advocate. And we're in this really hard position of not being able to provide legal advice to these individuals. We are not representing them. We're now at the point where we have accepted so many new complaints this year. We're totally inundated, and I'm I'm concerned that I need to stop accepting new cases because we just don't have the bandwidth for what we've currently accepted.
Senators.
Yeah, thank you for your testimony here. I think, in my head, I'm drawing parallels to some of the conversations we've had in the past about crime, actually, and the two main elements of, the likelihood of being caught and the length of time in which a case is being worked on in court. And when I see that the average investigation takes 649 days to complete, it makes me think that there are going to be many folks who have complaints that are going to lose trust in the system when they are wronged in a certain way. And with the changing legal landscape across the country when it comes to human rights, that I think that this is something that we should be investing in.
It's a serious problem. And also the people who feel that they've been wrongly accused of discrimination, what we call the respondents to these cases, are also waiting all this time to even get an interview. A lot of times it's 6 months to a year before we can even do interviews with parties. And in addition to having to wait so long to get some finality, they're also losing their emails. We're losing track of witnesses. The quality of the investigations goes down when things have to take so long. I often say if I had a duplicate of every single person in my office, then we would really be able to do the work. So I see that these two positions on the first page, another staff attorney investigator position, and someone who can solely be devoted to processing the intake calls and inquiries we get are just fundamental to us to be able to continue to meet the needs.
If you had to, and if you can't answer this question, I understand, but of the three, what do you feel is the most important or the most critical in your request?
Definitely the staff attorney and the intake specialist are the most critical. The outreach work is really important to educate folks about how to not break the law by accident, which happens a lot. Landlords don't know about fair housing rights. They can just become a landlord and, step in it by accident. And we offer some monthly fair housing trainings right now, but we're not getting out into communities enough. We're not able to spread the word either about people's rights or people's responsibilities under the law. So the outreach is like preventative work that I really wish we were able to do more of, but just to handle the caseload that we currently have, I feel like these first two positions on this sheet are absolutely crucial. But I do think being able to do more outreach work would result in maybe fewer complaints, right? Because maybe people would be more knowledgeable so they don't accidentally discriminate. But at the same time, it can also lead to an increase in cases because now people know we're here, they know what their rights are, and they're gonna, be seeking more complaints.
Do you know what the status is in the House Appropriations Committee on H725, or are they incorporating it into their budget bill, or?
I have not been given any reassurance about that. It's basically up on a list of many other requests that are more than they're able to satisfy last I heard. So there's going to be a priorities decision to make there.
Your increase from the administration, assume vacancy savings in a small agency that doesn't have many vacancies.
We don't have any vacancies now. We don't foresee any vacancies. I'm really working as hard as I can to retain the staff. Yeah. And staff retention is a major issue when everyone is overloaded all the time, and everyone who we're trying to serve is dissatisfied with how long everything takes.
So at the very least, even if you didn't get your 350,000 increase for new attorneys, you're short within your budget by what amount?
Just to level fund staff with no pay increases.
The level of service that you have available today, what are you short? What is the vacancy savings amount that you?
It's just over 24,000. Okay. I can give you that exact number.
Yeah, if you could get that to Amy, it'd be helpful.
Hi, Amy. The number is 24,862.
That's pretty exact.
It's in my, budget documents.
So
And
you're basically level funded less than 24,000
correct.
or 25.
That gives us.
Let's call it 25.
That gives us no money for professional development, for staff, like being able to, right now we're doing some trauma-informed lawyering training because everyone who we're working with is traumatized, and we're traumatized by working with them and not being able to serve them. Trying those kinds of things are really important to retaining staff. And so, and this year we operated with a $1,300 carryover. So I don't know what I'm gonna have for next year. It's not looking like much with recent increases in benefits costs and all the other things.
Thank you. Thank you for being here. And you may have said this and my brain may have just missed it, but I'm trying to do the math as to how many staff you actually, there's 3 attorneys, an executive assistant, and you?
No,
Okay.
we have 7 positions total.
Okay.
So that's me, and you're welcome to take a copy of our
Oh,
annual
thank
report.
you.
That helps summarize kind of what we have going on and what our process is. But we have myself, 3 investigators right now, staff attorney investigators. Last year, you may recall that a litigator position was created for us to do enforcement in court. So that makes 5, and then we have our executive staff assistant who answers all the phone calls and initiates all the complaints. And we have our director of policy, education, and outreach, Amanda Garces, who many folks have worked with. So she does such important policy work. It's really hard to find time to do a lot of the outreach work that we really need. And updating our website and just having any kind of social media presence is basically impossible with the current staffing levels.
Yes.
But I also fear if we get the word out more about what we do, that we will just have more cases that I have to turn away. Last year we accepted 41 new cases already. This year I've accepted over 65, and we've already initiated 46 just this fiscal year. So I'm at a point where I just have to stop taking cases and turning people away unless I feel like there's some reason to believe that we're going to be able to actually process their case in a timely manner.
So that means that people who have been discriminated against are having to be told, sorry, there's nothing we can do.
Yes, and go find a lawyer to represent you and file in court, because that's the only other place to go.
Who believe that?
And we do.
It's a long process to determine whether somebody has been or not.
And I am working on streamlining a lot of our processes and trying to make our reports more concise. So, but without compromising the integrity of those investigations.
Do you take police where somebody believes that they've been discriminated against by law enforcement?
Yes, police departments are a place of public accommodation under the statute.
So, and that's also dealt with by other agencies, am I correct?
There are, like, the Department of Justice could be a possible avenue, but if you're seeking any individual relief under state law, that we are the only entity that reviews that.
The ACLU does take on some of those cases.
They represent some folks in those cases,
Yeah.
but they don't do the investigative work that we do, or,
Do you work in conjunction with the ACLU on that?
They represent some parties that have complaints before us, but we are a objective, non-biased agency. So we don't work with them, but we interact with them all the time. Same with legal aid. Legal aid attorneys represent a good portion of our complainants. And those attorneys are extremely overloaded and overwhelmed with cases as well.
Senator Norris, do you have any comments or questions before you transition over to the floor?
Maybe already gone to the floor.
Maybe he's gone to the floor. We're on the floor at 10:30.
He's still on Zoom.
He's still on Zoom? Okay. Any other questions for me? Any other comments?
I think, the last point I want to make is that while we have grown our reach over recent years, and we've had Amanda Garces in her position for about 4 years, I think that's really resulted in us having there's more word about what we're doing. And we've had a lot of high profile cases, and that means we are just having an influx of requests for complaints. And I really don't want to have to be turning people away. But in the past, when we have had a vacancy in an investigator role, we have just outright not accepted new complaints during that time period. When last fiscal year, the executive staff assistant position vacated, it was empty for 2 months. We had no new complaints during that time, and we do not have a log of how many calls we received or inquiries, because there was literally no one to do that role. The executive director was trying to respond to, you know, day-to-day inquiries along with everything else. That was kind of, you know, that's the risk of if there is a vacancy turnover savings, there's just going to be an outright lack of service provided.
Thank you very
I
much.
really appreciate your consideration of all of this, and I'm happy to provide any follow-up information that anyone would like.
Thank
Would you like a copy?
I think I have one in
Okay,
education that I saw.
yeah,
So
that's right.
This
that's
all,
right.
this all meshes with what I saw over there too, so,
Yeah.
Okay.
thank you.
I'm just saying the same thing everywhere I go.
Thank you.
Yeah, I can get it
Can
out.
you get it out and leave it out? I'm gonna take it down to appropriation.
Thank you so much.
Keep it all in one place. Thank you. And I'll just keep it, over here on my other part of my desk and.
Yeah, if Senator Shubin as well, if you just leave your bunch of stuff, I'll file it.
Okay, I'm gonna, go upstairs and.
We're ready to adjourn.